Hey guys, what's up? Hey guys, what's up? Please let me know in the chat box that audio video is absolutely perfect. Very good morning, guys. Very good morning. Very good morning. Yes, guys. Quickly in the chat box. Let me see in the chat box. Yes, everybody. Very good morning. Very good morning. Yes, new day, new start. But the concepts are still old and we will quickly revise everything. But let's wait for some time, some minute, and then we will start today's lecture. Yes, friends, come on, quickly in the chat box. Let us start, friends. Let us start. Okay, quickly. I hope the note making is already done, friends. This is lecture 3, my dear friends. So make sure you already have these notes. These notes are available in the BB virtual app. You can just go there and quickly download all these notes. Yes. So this is lecture number 2. This was lecture number 2 notes I have already covered. So let us quickly revise what we have covered in yesterday's lecture. Friends, the very first thing we started with section 3A, which talks about members are jointly and severally liable. Yes, this is in case of public and private company where minimum number of member criteria is not been complied. So if in your company your minimum number, that is 2 or 7, your company the number of member is below to that, in such a case you have 6 months to add back. Now if you don't do that, then any transaction which has been undertaken will have the unlimited liability. Already I have covered this in yesterday's session. I have also discussed what is holding company and what is a subsidiary company. Holding company means father company, papa company, and subsidiary company means bachu company. Yes, holding company means whereby company holds more than half of share capital in subsidiary company. Correct? And I have given you examples how the things work. Also this example that whenever I say you have to hold more than half, you can hold it either by yourself or you can hold it through your subsidiary. Yes, this is already I have covered in yesterday's lecture. I have also covered what is government company. I have also covered what is government company. What is government company, my dear friend? Government company means a company which has been owned by central government, state government, or it can be any combination. So in any combination, it can be called as government company. But I have also mentioned if a parent company is government company, then subsidiary company will also become a government company. With this example, also I have completed associate company. I have also completed associate company. What is associate company? So associate company means company whereby you have significant influence. You have which influence? Significant influence over another. So whenever I say you should have Significant influence. Significant influence means control. Control. To get this control, you guys need to understand at least 20% of the share capital. How much? At least 20% of the share capital. How much? At least 20% of share capital with which it should be with that company. Correct? I have also taken some examples, real examples that always help you to understand how the things work. Super easy. Yes, super duper easy, super duper easy. Then I have covered what is small company. Small company means a company whose paid up capital is up to 4 crore and turnover up to 40 crore. You have to see both the things, both the things. However, in law it is mentioned that in future we can increase this number not exceeding 10 crore, not exceeding 100 crore. That is the thing which will be happening in future, my dear friends. Okay, next is these four items. These four items is super important, super important. These four companies are companies which are not small company. I have already given you some examples. And what was the objective? What was the advantage? I have covered. The compliance is simple and the cost is low. Yes, no cash flow statement, no, not required. Plus the merger, if you want to merge two small company, then the NCLT approval is not required. Then relaxation is on board meeting. So you don't have the board meeting provision, generally 4, but they can keep it 2. Okay, yesterday we also started section 8 company. Also we have started section 8 company, and today we will continue and complete section 8 company. Today we will continue and complete the section 8 company. Super duper topic. Yes, super duper topic. Today the main intention of revising is so that I would have complete this chapter. Yes, we will complete this chapter plus this topic as well. Friends, what is Section 8 company? Friends, Section 8 company means a company whereby your main intention, your objective. What is your objective? Objective is to promote arts, science, commerce, education, sport, religion, environment. That means you are creating a company where the objective is to social service, is to do social service. Correct. Now friends, there are certain restrictions already I've covered in yesterday's lecture. There are total 2 restriction. Section 8 company cannot do all these things. That is first Section 8 company is prohibited to declare dividend. They cannot declare dividend. In the question they will ask you, company made this profit, that profit, the company is planning to give dividend. You just have to straight away write no, they are not allowed. Okay, second one, always remember surplus should be reinvested. Surplus should be reinvested. This has already been covered. Yesterday I have uploaded an MCQ whereby everybody did mistake. The power to issue license is given to the central government. I have nowhere mentioned in the MCQ that who is right now controlling all these things. Always remember, the power to issue license is given to Section 8 company. Power to issue license is given to Section 8 company. Second, these power are now delegated to ROC. But however, you guys need to understand, the supremo, the powerful is the central government. Central government can revoke, yes, the power given to ROC anytime, any day. And last, what we have covered in yesterday's lecture, that upon registration, Section 8 company will get same power, same privileges as of limited company. This already I have covered in yesterday's lecture. I hope this is pretty clear and pretty easy, my dear friends. Yes or no? Yes or no, everybody. This was the super easy concept which we already know. Now today we will be continuing the Section 8 company, but I will be writing the new notes. So anybody writing notes of Section 8, you have to first take class 2 notes and then the class 3 notes. Okay friends, without any delay, let's get started. So let me go to Companies Act, BB Virtual and class 3. Okay, let me start with class 3 notes. So Today we will be covering the important topics. So please be attentive. Today is class 3. Okay, and I will continue with what? I will continue with section 8 company. I have already covered few topics. Yes, I have already covered the few topics. Now I will complete this concept. Now first understand the procedure. Yes, let us understand the procedure. I have not yet completed, my dear friends. I have not yet completed. I have not yet completed, my dear friends. We have to complete this section at company. Yesterday we did 4 points. Yes, these are the yesterday's notes. That is section and company's objective. Second, the restriction. Third, the power to issue license. And fourth is the powers and privileges. Correct? Now I am continuing section at company. Super duper topic. Okay. Now let me discuss with the procedure. It says if anybody, it says if anybody, it can be association of person. Yes, it can be association of person. Okay, it can be association of person, or it can be any person. So any persons or association of person. Please repeat after me. Persons or association of person. If they want to create a section 8 company, if they want to create a section 8 company, the procedure remains very simple. Friends, they have to write an application. They have to make an application. Correct? They have to file a form. They have to make an application. Who will make an application? Persons or association of persons. Persons or association of persons. Correct? You guys need to understand that we will be filing a form. Now, what is the name of the form? The number of the form is INC 32. Yes, what is the number? INC 32, incorporation form number 32, which is also called as spice. Yes, which is also called as spice plus. Called as spice plus. So, association of person will make an application where in form INC 32. Friends, to whom? You will make an application to whom? You will make an application to central government. You will make an application to central government. You will make an application to central government. Correct? You will make an application to central government. But you know, right? Central government has delegated this power. Central government has delegated this power to ROC. So let me write CG but bracket ROC. CG but bracket ROC. I hope you understand why I have written ROC in the bracket. Friends, I have a question. My question to you is it possible that central government can revoke the powers which has been given to ROC? Yes, central government has immense power to do what? Immense power to revoke. I hope you understood this. Yes or no, friends? Quickly, let me see the chat box. Yes, quickly. Come on. Let me see. Yes, let me see. Yes, super, super, super. Just let me see. Just let me see. Just give me 1 second. Yes. So who will make the application? Who will make the application? Persons or association of persons? Persons or association of person. They will file a form. They will file a form. Which form? That is INC 32. Correct? That is nothing but the Spice Plus. They will just file a Spice Plus. To whom? Central government, and they will file it to ROC. Easy, easy. So generally file it to central government, but you know, right, that central government has delegated this power. Delegated this power to whom? Delegated this power to ROC. Easy. Now, whenever you make an application, whenever you make an application where in Spice 32, you guys always need to understand there are certain attachments. There are certain attachments. You guys need to understand there are certain attachments. Now, what are these attachments? Let's understand that. What are these attachments? Let's understand that. Attachments, that means we need to submit all these things with INC 32. Correct? We need to submit all these attachments. Now, what are these attachments? Number one attachment. Please be focused because the concept is super duper easy and super duper scoring as well. This is the examiner's one of the favorite question. So don't ever try to miss this. Number one, you have to give me INC 13. Correct? You will give me INC 13. That is nothing but memorandum of association. Okay. Second thing what you will give me is INC 31. INC 13, INC 31. You will be giving in article of association. So you have to make an application. You have to make an application with application. With application, my dear friends, you will either file INC 13 or and plus 31, not or plus. That means we need to file MOA and AOA both. MOA and AOA both. Easy, easy. So a person or association person will make what? Will make an application. Will make an application. They will submit it to the central government. They will submit it to the central government with the attachments. Now, what are these attachments? Number one, INC 13. INC 13. Next is INC 31. Okay, G. Next, what is the next instrument? You have to give me two another form. Now, what are these two another form? First is INC 1414. You will give me INC 1414. Now, what is INC 1414? INC 1414 is nothing but declaration by PCA, declaration by PCS, and declaration either by PCMA or declaration by advocate. You will give declaration. Plus, there will be one more declaration. Don't worry, wherein we will learn in detail how to incorporate a company. Then automatically you will understand these are the forms that we need to give extra. So INC 14. You will also give INC 15. INC 15. So INC 13 is a memorandum. INC 31, that is AOA. INC 14. What is memorandum, by the way? Memorandum means the aims and objectives are mentioned. What is article, by the way? It includes the internal rules and regulation. And third, it says declaration by PCA, PCS, PCMA, advocate, and INC 15. INC 15 is basically given, it's also a declaration. This declaration is been given by subscriber. It has been given by subscriber. So these 3 to 4 things, it is a very, 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 very important. Now, whenever I say Whenever I say they will give a declaration, who will give declaration? These two people will give declaration. Always remember, you have to ask yourself what declaration they will give. You have to ask yourself what declaration they will give. So friends, they will give declaration of two things. Number one, they will give declaration of two things, that is Mao and Ao, that is memorandum of association and article of association is prepared is prepared as per section 8. Correct? So your memorandum and your articles is prepared as per section 8. Okay, good to go. Next, all conditions. Yes, all condition laid down, all condition laid down under section 8, under section 8 is duly complied. Yes, so friends, both the condition, both the things you have to declare, both the things you will have to declare. I hope you understand. There are total four important document: INC 13, INC 31, INC 14, INC 15. INC 13 is a memorandum, 31 is article, 14 is declaration, 15 is declaration. 14 is declaration by PCA, PCS, PCMA advocate. INC 15 is declaration by subscriber. Now what they have to declare? They have to declare two things: that memorandum articles are prepared as per section 8, plus all the condition laid down under this section 8 is duly complied. That means they have followed all the policies, all the procedures, totally they have completed. Okay friends, these are the attachments. Always remember, you have to attach all this thing while you are making an application. Friends, what are we learning? We are learning the procedure to create a section 8 company. We are learning a procedure to create section 8 company. We are just learning and understanding what is the procedure. So persons or association of persons, person or association of person will make an application in which form? INC 32, which is also called as Spice Plus. You have to submit all these things to central government, but central government has delegated this power where? They have delegated this power to ROC. Correct? They have delegated this power to ROC. Easy, super clear. Okay, now very important. Now the very important concept is the attachments. That means whenever we'll make an application, we'll also have to give some attachment. Imagine you are applying, you have to give some attachments as well. Now what are the attachment? Total 4 attachment. INC 13, that is memorandum of association. INC 31, article of association. INC 14, declaration by PCA, PCS, PCMA and advocate, and declaration by subscriber. Yes. Now what declaration we will be giving in INC 14 and INC 15? That MOA AOA is prepared as per section number 8, plus all the condition which is been mentioned under section 8 is duly complied. Easy. Friends, we have to give one more attachment, that is the fifth attachment. That is the fifth attachment. Again, one of the important attachment. That is what? That is the projected income. You have to submit what? You have to submit a projected income and expenditure. Okay, you have to give me what? You have to give me projected income and expenditure of next 3 years. I repeat, it's a projected income. So we will try to project that how much income and expenditure our sectioned company will incur in future. We will try to project. Always remember, we will always project the income and expenditure. We will always do that, but there can be a difference a bit different. It's totally fine, because ultimately we don't know what will be our income in future. But yes, it is just an assumption basis. We just make it so that central government is able to understand, is this company, is this sectional company is worth giving license or not. Easy. So the procedure is very simple. If today you want to start a section 8 company, the procedure is very simple. Number one, the association of person or persons will make an application to ROC. But friends, the original power was given to central government, but central government has given this power to ROC. Okay, we'll file which form? We'll file form INC 32. It is nothing but spice plus. Now, plus attachment INC 13, INC 31, INC 14, INC 15, and the projected income of next 3 years. Always remember, once you give the application, let me write here. Once, just stay focused. It says TG after receiving the application, if satisfied that all conditions are complied, then it will incorporate. Incorporate means they will start. Incorporate and issue license. Guys need to understand. Let me write this. Make an application S1 with attachment S2. You will give it to whom? You will give it to central government S3. Central government, if they feel it is perfect, then S4. What is this? S1, S2, S3 bogey number? No, it is the steps. Correct. Now, let me add one more statement here. It says after incorporation. After what, beta ji? Incorporation. Section 8 company will not add words like private slash limited. Always remember, say example, we have Reliance section 8 company called as Reliance Foundation. We don't call it as Reliance Foundation Private Limited. We don't call it as Reliance Foundation Limited. You need to understand, in section 8 company, we don't tend to use this word. Which word? This limited and private limited. So please be focused. You will not add these two words. This is what the procedure is, my dear friends. This is how you will create a section 8 company. The whole procedure is in front of you. Just have to revise and memorize from the notes itself. So procedure says what? Step 1, make an application. Step 2, give the attachments. Yes, you will make an application. Which form? In Spice Plus, that is INC 32. You will give it to whom? You will give it to central government. And central government, if they are satisfied that you have complied with all the conditions, then only they will give you license to operate. Plus, always remember, once section 8 company is duly formed, you guys are not at all, you have to remember that you are not at all required to use the word private limited and limited in your name. Easy. So this was the procedure. It is a continuing part what we have covered in yesterday's slide. This was class 2 notes. Yes, if you want this class notes, then you have to go on BB Virtual's website, or sorry, in the app, and in the app you can get this notes. It is uploaded there. Also, you will get, just after the lecture, you will also get the class 3 notes as well. Okay, just after the completion of the batch. Okay, now guys, always remember. No, remember what? Always remember. Remember what, sir? Remember that. Remember that. Super important. Super crucial. That, let us complete point wise. So fourth point is done. Let me start with fifth point. Okay. Let me start with fifth point. Fifth point says what? Can you alter? Alter means to change. Can you alteration of memorandum and article is possible? Lawmaker says, always remember, lawmaker says what? Lawmaker says Section 8 company. Which company? Section 8 company can alter. Wow. Alteration is possible? Yes, alteration is possible. What is the meaning of alteration? Alteration means change. Can you change your clauses of memorandum and article? Memorandum means it includes what? It includes aims and objective. Correct? What are the articles? It includes what? It includes, come on, yes, internal rules and regulation. These are things that you should know, my dear friends. Easy, simple. Okay. So, first question. Alteration of memorandum article possible, not possible? Lawmaker says Section 8 company can alter, can change, can alter, can change. What? It's memorandum and article only after. Oh my god, they can change it. Yes, they can change it, but only after they take approval. Sir, approval from whom? You guessed it in the chat box. Yes, only after approval. Only after approval. Approval from whom? So, approval from central government. Easy. You should feel it easy. You should feel it very, very light. Very, very light. So, total we have completed 5 points. Let's jump to the sixth point. What is the sixth point? Very, very important, and it says partnership firm. It is all about partnership firm. Partnership firm. Why we are discussing about partnership firm? Let us understand that, because that is very crucial and very, very important. Guys, what happens, in normal company, partnership firm are not at all allowed. Allowed to do what? Allowed to be a part, allowed to become a member. You know why? Because partnership does not have a separate legal entity. Yes, but however, partner of the firm can become shareholder, but partnership firm cannot act as a shareholder or member. But let me write an important point here. It says partnership firm can become member member of Section 8 company only. I have added this word only. Now, why I have added this word, you guys need to understand, because in normal and general case, Section 8 company are not at all allowed to act as a member in any other company. Yes, you are only allowed to act as a member in Section 8 company. Easy, easy, superb. So these are total 6 points what we have covered. I'm starting with last 2 notes. I started with the introduction, which says if you want to incorporate a Section 8 company, very simple. When your objective is art, science, commerce, education, sports, religion, environment, etc., you can form this company. That means your main motto is to do social service. Number two, how many restrictions are there? Total two restrictions. You cannot declare a dividend. Number two, whatever the surplus is, that will be reinvested. Number three, who has power to issue license? Section 8 company. Who has power? If you want to act as Section 8 company, who has power to issue license? Central government. But however, this power has been delegated to ROC. But always remember, the supremo of this section is central government. Always remember, upon registration, the Section 8 company will get the same privileges like of the limited company. Now, in today's lecture, I have discussed the procedure. You see the half-pager procedure, but it almost took me half an hour just to discuss what are the procedures are there. Okay, the first thing, association of person or person will make an application in which form? Spice Plus, that is INC 32. They will make an application and they will give it to central government. But with Spice Plus, they will have to give some attachment. MAO, AO, memorandum, articles, declaration, and declaration. There will be two declaration by professionals and declaration by subscriber. Now, what they will declare? They will declare that memorandum and article is prepared as per Section 8 and all the condition which has been laid down under Section 8 is duly complied. And if central government is satisfied, then central government will give you a license to act as a Section 8 company. But always remember, Section 8 company will never include the word private and limited into their name. Next, can you change your memorandum and articles? Yes, in Section 8, if you want to alter your memorandum and articles, it is purely possible. It is totally possible once you take approval from central government. So always remember, once you take approval from central government, only and only then it is allowed. Next, generally, partnership firm is not at all allowed to act as a member. But always remember, partnership firm can act as a member in Section 8 company only. Easy. We have covered all this thing very comfortably. Now, let us understand the seventh point. The seventh point I will be talking about is of merger. You tell me, what is the meaning of merger? Come on. What is the meaning of merger? You tell me, what is the meaning of merger? What is the meaning of merger? Come on. You tell me, what is the meaning of merger? Come on. Tell me, what is the meaning of merger? Very easy. Come on. You tell me, what is the meaning of merger? See, merger means when two or more company comes together. Correct? So, example, Vodafone India. They come together and they formed VI, Vodafone India. Yes, the Vodafone Idea company, that is Vodafone India and Idea, they came together and formed VI. In a similar case, my question is, can a Section 8 company is allowed to merge? Come on. Can a Section 8 company is allowed to merge? Now, friends, the answer is yes. The answer is yes. Merger of Section 8 company is allowed. Perfect. But there is a problem. In general cases, in case of normal companies, you can merge with any type of companies. See, let me give you an example. Say example, if I'm to a business of hotel, I can easily merge with a company who is selling tobacco. Example, ITC. Correct? So my question to you is very simple, that the merger of Section 8 companies allowed, but always remember, the merger of Section 8 company can be done only with Section 8 company. So you're not allowed to do with any other type of company. So long story short, if you are a Section 8 company and this is also a this is also a Section 8 company, correct? Then my dear friends, if today you want to merge, if you want to merge, you can merge. That means the merger of Section 8 company is allowed only with Section 8 company. Yes, it is only allowed. It is only allowed. It is only allowed with Section 8 company. It is only allowed with Section 8 company. Easy. The seventh point was on merger. The question was, is Section 8 companies allowed to merge? Lawmaker says yes, it is allowed to merge. Section 8 company can merge. Yes, they can. They are allowed, but they always have to make sure that they are merging with Section 8 company only. Only. Okay, friends. Now let's talk about conversion. Let's talk about conversion. Conversion of what? Conversion of Section 8 company. Which company? Section 8 company. Merger of Section 8 company. Merger of Section 8 company. Super easy. Friends, always remember how we will merge. How we will convert. Conversion means you are converting it either into a private company or public company. How to do that? Very simple. Law has mentioned a single line for this. It says if you are a Section 8 company, which company? Section 8 company. And today, if you're planning to merge, if you're planning to convert, already we have covered the merger part, into what? Into a public company or into a private company. So if you are a Section 8 company and you want to convert it into private or public company, then it is very easy. You can do it. You can do it how? Yes, you have to follow all the conditions. All the conditions laid down in the law. That means if you want to convert, you can convert it. How you can convert it? You can convert it. You can convert it. How you can convert it? You can convert it by following all the rules and regulation. How you can follow it? You can follow it by following all the rules and regulation. Easy, simple, easy. Now, very important. Plus, company shall pass special resolution. Company shall pass special resolution. Now, what is the meaning of special resolution? So, special resolution means whenever you want to take approval, you can take approval of the shareholder. See, always remember, company cannot do anything without the prior approval of their shareholder. They need a prior approval of their shareholder. If there is a prior approval of the shareholder, only and only they can execute all these things. Example, if you want to do basically change of name. First your company was Bipu Limited, now you want to make it BB Limited. Now friends, if you want to make it any sort of changes, you guys need to ask all this stuff. Friends, always remember, if you want to ask all these things, you guys need to be very straightforward. That is, you need to ask from your shareholders. Now, if the matter is very huge, the matter is very big, you guys need to understand we need 3/4 approval. three-fourth approval. Just imagine right now, if there are four people in the room, if three people decide this, then this is called as special resolution. Yes, just for just understanding of special resolution. But whenever I will teach you in meeting chapter, I will go in detail how special resolution is being defined. But right now, just imagine if there are four people, if three people are saying yes, then only we can convert and we can do all these things. Easy. This is only possible by passing special resolution. Easy. Friends, still we are discussing Section 8 company. This is one of the important part of company law. Yes, I hope you're there. And this is one of the toughest part, whatever we are covering. The toughest part. Correct? Easy. What are pointers I have already covered? It is super easy. Okay, let's now talk about merger is done, conversion is done. Let's talk about 8 point. Let's talk about ninth point. Now, in ninth point, I will talk about revocation. Now, revocation means what? Revocation means take back. Revocation means what? Revocation means to take back. To take back what, my dear friends? To take back. To take back what, friends? To take back the license. Always remember who has power to issue license. Who has power to issue license? The power to issue license is with the power to issue license is with a single person, that is central government. However, that power has been delegated to ROC. You guys need to understand a very simple concept, and that is what lawmaker says. CG has power to revoke license of Section 8 company. Correct? Who has power to revoke? Who has power to revoke? CG. Remember this thing. Who has power to revoke? CG. CG is having power to revoke. But always remember, again here, CG has delegated this work to someone. CG has delegated this work to someone. Now, who's this people? However, central government has delegated. What is the meaning of delegated? Delegated means to give delegated its power to RD. To RD. Remember class 1. In class 1, we have discussed a super concept, the hierarchy. RD is a regional director. Yes, so guys need to understand this power is been now delegated. Delegated means given. Given to whom? Given to RD. But friends, just like to issue license, the central government has given the power to whom? Power to ROC. And I have also mentioned that central government has autonomy power. That power can be withdrawn anytime, which has been given to ROC. In a similar fashion, the revocation of license can also be done. The revocation of license can be done by central government. However, this power has been given to RD. But remember this thing, the supremo of revocation of license is central government only. That means if central government feel that revocation power which is been delegated to RD need to be revoked, need to be taken back, they can do so. Always remember, this is the clean chit rule. Clean chit rule. And that is what? If central government is in the opinion that in public interest, which interest? Public interest. That in public interest, such powers which is delegated, which is delegated to RD can be Revoked. This is there. This is the unsaid rule. But yes, I have to mention this. That is the whole and sole reason. Correct? Always remember they have power to revoke. But always remember why. The question is why why RD shall revoke license. Correct? Whenever I say RD, that means CG bracket RD. Why RD shall revoke license? This is the question. Correct? That means we need to understand the topic called as grounds of revocation. Yes, grounds of revocation. That means what are the grounds? What are the grounds that a license can be revoked? So there are a couple of grounds. Let us understand. It is number one ground where Section 8 company acts fraudulently. Acts fraudulently. That means acted, you have not acted as it was required to act. You have acted over smartly. You have acted fraudulently. This is one of the ground where your license can be revoked. Your license can be revoked. Number one. Number two. Remember these things. Super easy. Next is where Section 8 company violates. That means to break. Violates provisions of Section 8. So, if you have acted fraudulently or if you have violated a provision of Section 8, you're gone. Your license is gone, my dear friends. Third, very important, where Section 8 company contravenes. Contravenes again, not to follow. Contravenes terms and conditions. Terms and conditions on which license was provided or granted. Easy. So this is or this is or, and also we have one more or. These are the grounds. If RD or CG they are planning to revoke license, these are the ground. Ground number one, that Section 8 company have acted fraudulently. Number two, Section 8 company violated the provision of Section 8. Okay. Section 8 company contravenes the provisions, terms and condition. On those terms and condition, the license was given to you. Okay. One more. Where Section 8 company act against public interest. If you are acting against the public interest, then you're gone. Then what are the keywords? Fraudulently is the keyword. What is the keyword? Violates the provision of Section 8. Keyword. Contravenes the terms and condition. Against the public interest. So these are the words which a person need to be focused while writing the grounds. It is very important. You can expect in the exam either a direct question or a MCQ question. Yes, or a MCQ question. Yesterday I uploaded a question on Instagram, but everybody given the wrong answer. Yes, everybody has given the wrong answer. The question was related to section 8 only. Okay, friends. So this was the ground of revoking the license. But always remember that central government bracket RD will always give you OOBH. They'll always give you OOBH. So RD before making an order of revocation, that is they're planning to revocation, that is they're planning to revoke, always they will provide what? OOBH. What is OOBH? Opportunity of being heard. OOBH, opportunity of being heard. Easy, and this is a super topic. Always remember, always remember, if you have violated, if you have violated the provisions, what orders central government can give? So simple is, what orders central government can give? This is the question. What orders central government can give? This is the valid question. That is what. First, they can ask you to convert the company. Step 1. Number 2, they will ask you to wind up the company. Yes, that is, they will ask you to complete the winding up procedure. Or they will ask you to merge or to amalgamate. Always remember the merger and amalgamation. Always remember the merger and amalgamation. The merger and amalgamation will be with the sectioned company only. Okay. So these are the important things that you have to focus regards to section 8 company. Finally, we have completed. Finally, there are so many things related to section 8 company. But also remember one thing. Let me give you a gist about that concept. If you're planning to convert, my dear friends, there is a whole procedure. Let me just narrate you the procedure. So example, if you want to convert your section 8 company into private or public, first you will pass the resolution. You'll also give an explanatory statement. Now I'm not discussing this, what is ES and all these things, that is explanatory statement, because there will be a separate chapter where I will discuss what is statement and all this thing. That's the reason. After you have the understanding about the incorporation of any company, then I will teach you the conversion part. Yes, then you will feel it bit easy. Let us quickly revise. So I'm referring two things. First, class 2 notes, and second, today's class 3 notes. Correct? First point, why we have formed, clear. Restriction to restriction cannot give dividend, and they can only form for charitable purpose. Next, they have power to issue license. Yes. And who has power to issue license? Central government. Always remember, now they have been delegated to ROC. Yes, super easy. Next, under section 8, the powers, basically the privileges, the power will be same as of limited company. Next, the procedure. I came to class 3 notes. This is the procedure. This is the procedure that a person need to follow if they want to create a Section 8 company. The Association of Person of Person will file an application to CG, that is ROC, and these procedures will be completed. Now, friend, these are the concepts. Can you alter your MOA AOA? Yes, you can alter your MOA, but you need a approval from CG. Next, can a partnership firm become a member of Section 8 company? Yes, they can. Next, merger is allowed. Yes, merger is allowed, but Section 8 will merge with Section 8 only. Conversion is allowed. Yes, but friends, always remember there is a process. There is a huge process which I will discuss it. Don't worry, I will be discussing in a very good procedure format, but not now, because if I teach you on the very third class, you will feel it very heavy, because there are very different government officers which is mentioned in that part. Then next is revocation. Can you revoke the license? Yes, central government has power to revoke. And what are the grounds? Always remember, you will always get OBH, that is opportunity of being heard, and the order of central government. If you're planning to file, you can convert, you can wind up, you can merge, you can do all these things. Easy, perfect, super duper easy, super duper easy. Yes, yes, yes. Superb, superb. I hope you're feeling bit good. Why? Because the next topic what I will start is one person company. Which company, my dear friends? One person company. What a topic! One person company. So it is mentioned under section 2, clause 62. Okay? Section 2, clause 62 is mentioned here. What they have mentioned? They have mentioned what is OPC. Since OPC is a huge topic, it will take good number of time. So we'll take 5 minutes break and then we will start with this beautiful concept. Okay, let's take a small mini break of 5-10 minutes and then we will start again. Hello, guys. Come on. Very, 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 very quickly. Come back, come back, come back. Please, come on. Everybody. Yes, 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 yes. People, come on. Let me see. We are back, friends. We are back. Super. Let's get started. Let's get started. Super concept now. That's the reason we took a break. And let's get started now. We are starting with one person company. We are starting with one person company. What a super topic. You know why? Because this concept is a very very unique topic. Let me give you the gist what is basically an OPC. You guys need to understand that we were having a very good system of functioning as a business house. Like you can act as a company or you can act as a sole proprietor in sole trading concern, correct? But sole trading concern were having some of the other problem. There were certain problem in soul trading concern. There were certain problem that need to be addressed and redressed, my dear friend. So soul trading concern was having some problem, plus companies also having some problem. Let me discuss that. In soul trading concern, there is a very huge problem of unlimited liability. You have already studied this in 11th standard. Second big and a very, very huge problem, very, very huge problem. You know what it was? The very, very huge problem. The second important was the stability problem. Stability problem means the functioning, the operation of sole trading concern is having a very big question mark. So example, if I am the sole trader of any company, if I'm a sole trader of a company, if I die tomorrow, now friends, very simple, if I die tomorrow, who will run my operations? Who will dare to run my operations? No one. So the two biggest problem of sole trading concern, first is the stability part, and second one, we are just one is stability part, and second is the liability part. This was the huge problem, and that the reason in the business world we had partnership act and all these things. But company is also a very good system, but even company has some demerit, like the lengthy procedures. Like the lengthy procedure, you have to follow so much of provisions and procedures, and then you can take decisions. Example, there is a delay in decisions as well. So in companies there is a huge problem that decisions are always delayed because there is a hierarchy to follow. So OPC was basically incorporated, or they have basically introduced. You know why? Just a good feature of company and good feature of sole trading concern is basically added to a single institution called as OPC. Very simple. Let's take an example. I have an idea, but I want to operate in a company system. So I basically always have to take my wife with me. So me and my wife actually started a company, a private company. Now, friends, idea is basically created by me. It's my money. So ultimately, I have to drag one more member just to comply with the provision of Companies Act. Hey, that's the reason, my dear friend. Good feature of company, and good feature of sole trading concern collated together. We formed an OPC. Correct? OPC. Now, let us quickly understand what is OPC. So, OPC is basically a private company. What? Yes, it is a private company. Remember this thing. It is a private company. It's a private company having only single member. You need in private company, we used to need two directors, but here you can work with even minimum director as well. So let me write what I've just now said. I just now said it is a company. OPC is a type of type of private company. OPC is the type of private company. OPC is a type of private company. That means private company and OPC is same. Yes, but guys need to understand there are certain rules which is applicable on private company is not applicable on OPC. Correct? So example, minimum number of members required to start a private company is 2. How much? It is 2. But in case of in case of OPC, it is only 1. Easy? Okay. Second, OPC is a type of private company. Second, having how many members? So OPC is having only one person. As what? As a member. OPC is a type of private company. Yes. Having only how many number of person as a member? 1. Minimum. How many number of directors? Again, only 1. You guys need to understand OPC is the type of private company having only 1% as a member, whereby minimum directors will be 1. Okay, okay. Now, question. My question is, say example, in private company, we tend to add the word private limited. Correct? So at the end, we always used to add this word private limited. Always, always. So if a OPC is a private company, then how I can basically divide, how I can identify that this is an OPC or this is a private company. I hope you understood my question. My question is how I will identify in real life that this is an OPC and this is basically a private company. Because both the companies are private. Private company is also a private and OPC is a type of private. So how I will get to know that this OPC is a private company? So very simple. In the name, we will do something. Say example. What will be the examples? It says name will contain words OPC in brackets. So by just having a look on the name of the company, you will automatically understand that friends, you are doing great job, that is identifying the OPC. Now, so let's take an example. So example, Pipu Sir, Private Limited, bracket OPC. Easy. So this is what the example is. Example, Bipu Sir, Private Limited, nothing but OPC. Easy. Now, this was nothing but you can say first point, meaning. Correct? First point, nothing but meaning. What is OPC? OPC is a type of private company. What is OPC? OPC is a type of private company. OPC is having only one person as member. Minimum director is how much? 1. And name will contain OPC in brackets. Easy, simple. Now, if you want to incorporate OPC, the question is, who can incorporate OPC? Who can incorporate OPC? So. First, a natural person. Which person? Natural person. Who is citizen of India. Who is citizen of India. Yes, whether or not, whether or not resident of India, whether or not resident of India. So the condition is who can incorporate OPC, who can start OPC? Natural person, citizen of India, whether or not a resident of India or not. So let me disclose in detail what all things are required. So it says natural person. Natural person means human being, you and me, you and me. That is artificial persons. Artificial persons cannot form OPC. Artificial person cannot form what? Cannot form OPC. Easy. Cannot form what? Cannot form OPC. Clear? Artificial person cannot form OPC. Okay. Friends, always remember the natural person criteria is the compulsory criteria. A human being like you and me only can form OPC. So, artificial person can form a company. Yes, Reliance created Jio. So, Reliance is basically the creator of Jio. Correct? But if you want to be creator of an OPC, compulsory, you need to be a natural person. Okay. Whenever I say citizen of India, whenever I say you should be citizen of India. Citizen of India, that doesn't mean that you should have an Aadhaar card or PAN card. Citizen of India means you should be either you have taken birth in India. So there are various rules and regulations. You need to be citizen as per Citizenship Act 1955 and amendments made there under. The last amendment they have made in the year 2019. You guys need to be you need to be citizen of India. So natural person rule is compulsory rule. Citizen of India is also a compulsory rule. Whether or not a resident of India is basically an optional rule. Because it says whether or not. Whether or not. You get this? Whether or not. Correct? Whether or not. Correct? Okay. Guys need to understand whether or not resident of India. First, let us understand what is the meaning of resident of India. So let us understand what is resident of India. It is optional, but still I have to teach what is the basic meaning of ROI. ROI means minimum 120 days. How many days? 120 days. In last financial year, you were here. You were here in India. If you were here in India, then my dear friends, this 120 days criteria you need to, there's 120 days criteria. If you're following this 120 days criteria, then you will be resident of India. So example, I was in last year, some of the time I was in Dubai, some of the time I was in the UK, and some of the time I was in India. But friends, it was very like I have sufficed all the rules of 120 days. Correct? Easy, simple. Now, minimum 120 days in last financial year you were in India. Last financial year to describe or to decide the status of this financial year, I have to check last financial year. Minimum 120 days. But as I have mentioned, it is Optional. It says whether or not. Now just adding this word, by adding this word, it became optional. Now, whenever I say it has become optional, that means previously what people used to do, an NRI was to come to India, used to stay 120 days just to fulfill this criteria. Now, government wants more and more people to be active and take participation in the corporate world of India, and that's the reason it has become optional now. That means that means NRIs who used to struggle a lot just to maintain this condition, now they can be very much relaxed. That means NRI can also incorporate OPC in India. Mind you, my dear friends, I have mentioned this word NRI, non-resident Indian. Non-resident India. As example, this financial year, maximum time I was in Dubai. Maximum time. Correct? So, if I'm sitting in Dubai, if I'm sitting in Dubai, can I form OPC in India? Yes, because I am NRI. For example, I met a girl in Dubai called as Julia. Julia is a Russian. Now, a Russian cannot form OPC in India. Why? The main criteria is Indian citizen. I am Indian citizen, but I'm staying outside India. I hope you understand. Easy. So this is the compulsory rule. Compulsory rule. Compulsory. Easy. Okay. So I have a very important question. So the question is, you know what? If we are starting an OPC, the question is if we are starting a OPC and you said OPC is a basically a good combination of sole trading concern and good combination of company. This is the combination. Correct. This is the combination. This is how it works. This is the combination. This is how the set work. But my question to you, still the problem is there. The stability problem. You are just saying OPC is basically a company having only one member. That means if something happens to that member, what next? That is the question. Don't worry, my dear friends. If you're creating an OPC, you will always give a name of a nominee. You'll always give a name of nominee. The nominee will act as a member in case of death or something happening with the member. So, example, if I'm planning to create an OPC, I will nominate my mother or my wife or my sister as what? As nominee. So, in any case, something happens to me, they will take over the business. So, the problem of stability, which was a big question mark, that has been duly solved. Easy. Okay. Okay. Third point. What is third point? Third point is nothing but what I have just now said. I just now said that we will create a memorandum. We'll create a memorandum. I said memorandum will contain. Contain what? Contain name of a person. Name of a person. This name of a person is very important. It should contain name of a person who will who will be called as who will be called as nominee. Very important. So nominee is that person, my dear friend, that person, my dear friends, who will be acting as a member if something happens to the member. Easy. Now always remember nominee nominee will become member. Always remember, nominee will become member of OPC in the event of death or incapacity. Incapacity of member. Whenever I say member, I mean the original one. I mean the original member. Yes, so nominee will become member of OPC in the event of death or incapacity of member. That means the original one. But always remember that we will always take prior consent. Now, prior consent from whom? Prior consent from the nominee. We'll take prior consent from whom? We'll take prior consent from nominee. Yes, nominee to act as nominee. Easy to act as nominee. Always remember, for this we will be creating a form or we'll be using the form called as INC3. This is the form. Easy. So, if you are creating a concept of OPC, the concept of OPC is easy, but the concept of stability was difficult. The concept of stability was taken care by adding a person called as nominee. If we add a person nominee, so nominee will take care of the OPC in case the member, the original member, something happened to him. So this is the whole story. Okay, friends, these are the concepts what we have just now covered. So, number one, the meaning. Number two, what are the condition if you want to form a OPC? You need to be a natural person, citizen of India. Whether or not resident of India, it's just basically it is fine if you're ROI. Even if you're not ROI, it's still fine. Next is memorandum. In the memorandum, we'll always write a name of that person. That is, the name will be of nominee. Why we will add the name of nominee? Reason is very simple. So in case of death or incapacity of original member, that person will act as a member. Always remember, we'll always have to take prior permission of nominee. Now friends, there will be a huge scene related to this. Huge scene. Huge means huge. First, let me give you an example. Don't write the example. Then I will narrate you the story. Yes. So the point is related to nominee. Uh, Before narrating the story, let me take some easy point so that you will feel more comfortable. Let's take an example. If today the concept what I wanted to discuss is related to nominee, my question is, can you change the nominee? This is the question. Is nominee is allowed to withdraw their name? What happens if a member dies? What happens if nominee is also a member? So these all things are there. So we'll discuss it in a while. Don't worry. Let's take one simple thing. So my question is, if today I am creating an OPC, can I convert it into private or public company? So lawmaker says yes. Lawmaker says OPC can convert itself into any other public slash private company anytime. Previously there was some number of years and threshold, but it is now anytime. Simple. Okay. Fifth point. Always remember this restriction. That is, OPC cannot, never do business Never do business. Business of what? Business of NBFC. Business of investments in body corporates. For now, for time being, you understand body corporate means company. For time being. Next condition. Fixed condition. Very important. It says what? OPC cannot be incorporated as Section 8 company. Oh my god. Oh my god. OPC cannot be incorporated, or I will say not even converted. In fourth point, I have mentioned that OPC can convert itself into any other public or private company, but they cannot convert themselves into Section 8 company. So now you cannot create, you cannot incorporate Section 8 company as OPC. Also, if you're an OPC, you cannot convert yourself into a Section 8 company. Simple, easy. Okay, friends. Seventh condition. This one minor. Why I am discussing this point? So that just you should feel it comfortable. Minor. So minor cannot act as member nor nominee. Oh my god. Minor cannot act as member nor nominee of OPC. Easy. So minor cannot act as a member or nominee of OPC. Easy. Next. Very, these points are very easy. Now, 8 point. Now, this 8 point was very important. So I will discuss in detail. It says single person. Let me draw that person. Single person. Please remember the restriction. Huh? Single person cannot become member more than one OPC. That means a person can form OPC and they cannot form more than one OPC. If I want to become an if I want to act as a member in any OPC, I will be doing one thing at a time. So a single person cannot become member of more than one OPC. Double dating not allowed. Double dating not allowed. Next. Next. Single person cannot become nominee of more than one OPC. Again, what? Double dating not allowed. Be it a member, be it a nominee, you will be acting as a member or nominee in not more than one OPC. Not more than one OPC. This is the golden rule. Let me give an example. Let me give an example. Correct? Example. This is Ranbir Kapoor. Ranbir Kapoor is a member of RK Films Private Limited bracket OPC. Correct? This is the name of the company. This is the name of the company. I hope by seeing the name of the company, you will be able to understand this is an OPC. And Ranbir basically made nominee to, to Alia Bhatt. My favorite, Alu. Correct? But even your Bipu sir, even your Bipu sir is a member. Correct? Member of what? Member of XX Private Limited, OPC. You remember this? We have a company which create educational content. Yes, educational content. Even this is an OPC, private limited. Let me add this word, private limited, OPC. Easy. Now, my question to you: can I keep RK as a nominee? Yes. Can I keep Alu as a nominee? No. Got the point? My question is: can I keep RK as nominee? Allowed. Why? RK is member. So he's not acting as a member, he's acting as a nominee in another OPC. It's fine. Can Alu? No. Why? Because Alia is already acting as a nominee in RK Films Private Limited. So she cannot act as a nominee in my OPC. Perfect. Easy. Sure. Simple. Now, at a time, you will be acting as a member in only one OPC, or you can act as a nominee in only one OPC. But I have not yet started complicating the concepts. Let's come to the ninth point where I will discuss the provision related to nominee. Very important. Nominee. Very, very important. Guys, remember this thing. Remember this thing. Once the nominee is appointed, yes, once the nominee is appointed, can we change the nominee? That's what the cases are. So, my question is first case, second case, third case. First case is, can withdraw his consent at any time. Yes, first case is this. I will discuss in detail. Member can, member can replace nominee at any time. Very simple. There are two important cases, just I'm starting. First, that if you're acting as a nominee, the question is, can you change the nominee? For example, if I'm the member and you're acting as a nominee, if I'm the member, you're acting as a nominee, I'm the member, you're acting as a nominee. If I'm the member, you're acting as the nominee. Can I remove your name anytime? Can I remove your name anytime? I don't like you. I want to do breakup. So yes, I can remove you anytime. Since you know double dating not allowed. Second, if you are acting as a nominee, can you withdraw your consent? You said I want to do breakup. Even you can say you want to do breakup. There are two important scenarios. Let us start with the first one. Now, what is this first one? Let me discuss this first and then discuss this second. So member is replacing nominee at any time. Member is replacing nominee anytime. So member will have to give or have to inform what? Let us understand the procedure. The procedure is very simple, my dear friends. So it says member should do what? So member should inform whom? Inform company. Yes, and consent of new nominee should be obtained in which form? Remember, friends, inform INC3. In which form? Inform INC3. Which form? They have to obtain their approval in INC3. First and very important. First and very important. So if today I am the member, you are the nominee. Can I change you? I can change you anytime. I will just have to serve notice to you and I will inform the company. And whosoever will be acting as a what? Acting as a nominee, I will take permission again from that person. Always remember, company will have to inform this. So company shall inform to ROC within 30 days. How many days? Within 30 days, inform INC4. Your company, in your company, you're doing breakup and patch up. How government will come to know? In your company, if there is a breakup and patch up, these things will be informed by the company to the ROC by filing which form? INC4. Two things. So if a member wants to want to replace nominee, they can do it anytime, whereby member will serve a notice to the company and a consent from the new nominee in which form? INC3. Friends, ROC will how ROC will get to know that you are doing this breakup and patch up? Very simple. You just have to inform to ROC within how many days? 30 days. How many days? 30 days. In which form? In form INC4. Easy? Easy? But remember this thing. Remember this thing. Any change in the name, any change in the name of nominee shall not change, shall not change memorandum. Friends, in chapter number 2, I will teach you what is a memorandum, and I will also teach you there are various part of memorandum. There are various part of memorandum. There are various part of memorandum, and there is a part called as succession clause. Succession clause is basically a clause, a part in the memorandum whereby we write the name of the nominee. Lawmaker is very clear with their view. The view is, if there is any change in the nominee's name, you will not change the MOA. Then how public will come to know that there is a change in the nominee? Don't worry, INC4 will be available in public domain. Easy, simple, super simple, super simple. Now, my question to you. In first case, you did the breakup. But in the next case, nominee is doing the breakup. Yes. So for this, there is a process. Now, what is the process? Very simple. What is the process? Inform Who will inform? Nominee will inform because nominee is removing their consent. So, nominee will inform to member of OPC to OPC. So, inform two people. First is member of OPC and second is OPC. Now, if it has been informed to member of member of OPC will have to do something. And if it is informed to OPC, then OPC will have to do something. So let's start with this. Member will do what? Member of OPC will appoint new nominee. They will appoint new nominee. They will appoint new nominee. Who will appoint new nominee? The member will appoint new nominee. You know, within how many days? So within 15 15 days. Within how many days? Within 15 days. Somebody asked me, sir, what if that person dies in this 15 days? Company closed. Yes, but you have to appoint within how many days? 15 days. You not only have to appoint a new nominee within 15 days, but also you have to take permission. You have to take permission. Permission from whom? You have to take permission from whom? Permission from that nominee, new nominee. So you have to take and obtain consent from such person in INC 3. Easy? Remember this thing. Remember this thing. Once this is done, member will inform this to whom? Company. Member should inform company and company will inform ROC within how many days? Within 30 days by filing INC 4. This is what the story is. Whatever I have covered, this will be done by the member. This will be done by the member. Member will do all these things. But friends, once the nominee has withdrawn their consent, OPC will have to do one more thing. Once they have once the the consent is withdrawn, OPC will file INC 4. Removed, withdrawn the consent, immediately inform ROC. Member will immediately go and appoint someone within 15 days, and when informed to the company will inform to the ROC by filing INC 4. This is the story. This is the story. Easy, simple. Now friends, it was not that complicated. But we have one more case which is complicated. It says nominee becomes member. Nominee becomes member. When? In case of incapacity of member. I am acting as a member. You are acting as a nominee. Something happened to me. I died. You become what? You become what? You are nominee, and you now after my death you become the member. So what is the procedure? It says New member will appoint nominee. What is the time period? The time period is same. So we'll appoint nominee within 15 days and obtain what? Consent in form INC 3. Same to same concept. Yes. Now what is the task of company? Company will inform the same to ROC within 30 days by filing which form? By filing INC. Oh, so this is the point which is in repetitive nature. Easy, easy, simple. The question is, I have discussed so many things about nominee. Friends, who can act as a nominee? This is the big time question. Who can act as a nominee? This is a big time question. So lawmaker says, who can act as nominee? Similar case, you need to be a natural person. You need to be a natural person. Also, you guys need to be citizen of India. Easy. Plus, shame to shame. Shame to shame. It is whether or not a resident of India. Easy. That means even NRI can incorporate OPC, not only incorporate, but yes, can act as a nominee. Natural person, citizen of India, these things are very compulsory. So I have one more case to discuss. Very important case to discuss. Very important. Very super. Very crucial. What should I say? Very important. Very important. Friends, let me give you an example. Don't write this. Write this. Don't write this. Don't write. I'm just doing some example work for you. Simple, easy. So let me change this example now. RK is having an OPC. RK is member, and Alia is acting as a nominee. But Alia is also having her own OPC. Possible, yes, possible. A person always, you guys need to understand, a person at a time can become a member of only one OPC, and at a time can become nominee of one place. At a time. Correct? At a time. This is a simple, sober rule. At a time, we will do all these things. Correct? Correct. Up now. No. So, Alia has appointed Bippu sir as what? Bippu sir as nominee. I think this arrangement is absolutely perfect. This arrangement is absolutely perfect. Yes or no? Yes. This arrangement is absolutely perfect. Now, you know what happened? You know what happened? RK died. Who died? RK died. Correct? Now, if RK died, RK died, what will happen? If RK die, something will happen. Something will happen. What? Alia will become member. She is already a member of XX Private Limited OPC. Now she is becoming a member of RK Films Private Limited. She's already a member of XX. Now, because of this situation where RK dies, you guys need to understand that Alia is now acting as a member of her own OPC, and she was acting as a nominee. Because virtue of a nominee, she became a member of RK's OPC. Complicated situation. You are you're no more. So Alu become the member. She's member here. She's member here also. Not allowed. Don't worry. Don't worry. Alia should elect any one OPC within 180 days. Very, 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 very important. Please remember these days. That is very important. So guys need to understand a very simple thing, that if RK dies, so Alia will become member of both the OPCs. It is not at all allowed. If this is the case, by the virtue of being a nominee, you become the member, because the member is no more. So you're a member in both the OPC. Don't worry, my dear friends. You have to elect anyone within how many days? Within 180 days. This is the super duper concept of OPC. Super duper concept. Super duper concept. Okay, we have covered today section 8 company, and we have covered OPC. Correct? Correct. Now, let me start a topic which is a very small topic, and that will complete in just 10 minutes. Yes, just 10 minutes. And what is that topic? Let us start with dormant company. Which company? Dormant company. Dormant company means inactive company. Dormant company means inactive company. So what is a dormant company? Very simple. Dormant company means company. Dormant company means company which uh, uh, dormant company means company which is formed for future projects. Easy. Which is formed for future projects, or to hold assets or IPR. What is IPR? Intellectual property rights, goodwill, trademark, patent. Yes, these things are IPR. So you have formed a company for a future project or to hold assets or IPR. Correct? 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 Hold assets or IPR. Or you have formed it for future projects. Let me highlight this. You have formed this company for future projects, or you have created this to hold assets or IPR. Remember this keyword. Always remember, always remember, you should not do significant accounting transaction. Does not have significant accounting transaction. Significant accounting transaction. Significant accounting transaction. Significant accounting transaction. Correct? Significant accounting transaction. Significant accounting transaction. Significant accounting transaction. So if your company is formed for a future project, if your company is formed for a future project, or to hold asset, or to hold asset, plus you will not do any significant accounting transaction. Yes, significant accounting transaction, sir. Or our company is an inactive company. Simple. A company can be called as dormant company, which has been formed for future projects or to hold assets or IPR, or it is an inactive company. Remember this thing, when you are formed for future projects or to hold assets or IPR, it does not have any significant accounting transaction. Always remember, if you want to act as dormant company, if you want to act as dormant company, uh, it says company may make application to whom? ROC, and obtain the status. And obtain the status. Which status, my dear friend? That is status of dormant company. You have one more way. If you don't file your financials, still you will get the dormant status. So these are the things that you guys need to always remember. But guys, whenever I say significant accounting transaction, whenever I say which transaction? Significant accounting transaction. Whenever I say significant accounting transaction, there are four items. How many items? Four items that shall be not considered as a significant accounting transaction. Okay, let me write. Following transactions are not significant accounting transaction. कौन सा ट्रांजैक्शन बोल रहा है? Which transaction they're mentioning, my dear friends? Significant accounting transaction. Always remember, significant accounting transaction means what? That is very important. Whenever I am mentioning some transaction, these transactions shall not be considered as significant. See, friends, if you are creating a company where you're taking a status, where you're taking a status of an inactive company, you guys need to understand you have formed your business or company for future projects or to hold IPR, but you will not do significant accounting transaction. But friends, even if you have formed the company, there are certain payments that you have to do. Say example, any fee payment. Say example, you need to maintain the office. Say example, you have to make some payment under the law. Say example, property tax, or you're making an allotment of shares just to form this company. Friends, this is an accounting transaction, but law has considered it is not a significant accounting transaction. But if you do any transaction other these four things, it will be considered as significant. And ultimately, if the status is dormant and still you are doing significant accounting transaction, a penalty will be levied on the company. Simple. Acha, whenever you study dormant company, you guys need to focus on section 455. Section 455 is related to this. But for transaction, number one, you are making payment of fees to ROC. If you are making payment of fees to ROC, not a significant accounting transaction. if you are making the payment made to maintain its office and records, for example, rent, registers, these all things basically shall not be considered as significant accounting transaction. Significant accounting transaction. Next, if you are making payment under this act or any other act, for example, I have mentioned you have to pay water tax. So, example, you have to pay property tax. You have to, ultimately, even if your company is not working, you need a registered office for this water tax, property tax, whatever it is applicable. You have to pay that. And at the last, allotment of shares. Friends, if you want to make a company, Section 3 says what? If you want to form a private company or a public company or whatever company, you always and always and always have to make sure there is a member. So even if your company is dormant, but you might have created this company by accepting shares, accepting money, and you've given the shares to them. So lawmaker says if you're making any allotment, it is totally fine. Ha! We have completed this topic as well. So dormant company means company formed for future projects or to hold assets on IPR, but does not have a significant accounting transaction. Now to take a status of dormant, you can apply to the ROC and ROC can give you status of dormant. Now whenever I say significant accounting transaction, always remember these four items shall be not considered as significant accounting transaction. Voila! Completed. Correct. So today we have completed section 8, OPC and dormant company. Mostly in class 4, we will able to complete our preliminary chapter. I hope you know, Institute has included all the definitions, but I am trying to create base from your foundation. Majority of the topics you're learning is basically a part of your foundation. I am just upgrading the content as inter level. Hope so, friend, you understood all this thing. This is the time to sign off, my dear friends. I will see you. Tomorrow is Sunday, so I will see you directly on Monday. You have good number of days. 3 lectures we have completed. Please make sure you go home and study ASAP. You need any help, I'm always available. Yes, but make sure you are writing the notes in the class itself so that you have a habit of creating notes, because at the end of the day, your notes is your Bible. Yes, it is your efforts, and your effort should enshrine in your marks as well, my dear friend. So I will see you in the next lecture. Till the time, bye bye, take a good night. And yes, in next 30 minutes, your accounts lecture will be live in the same YouTube channel. Yes, the pacer will be coming, and next will be the DT that will be taken by Agam Dalal. Sir, bye bye, take care, good night, and stay tuned for awesome lessons. Bye bye, guys, and see you very, 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 very soon. Yes, bye, guys.